Warning disclaimer. Nothing contained in this report constitutes legal, medical, financial, or official advice of any kind. This content is presented strictly as news reporting and editorial commentary for informational and entertainment purposes only. News is news. It is not legal advice, financial advice, or medical advice. Do not treat the following anecdotal stories, case summaries, legislative updates, or editorial observations as professional advice. Always consult a licensed attorney, qualified medical professional, or certified financial advisor for guidance specific to your situation. The creators of this content are not responsible for any actions taken based on the information presented herein. Daily Legal News Roundup, May 3, 2026. Supreme Court, Immigration, AI Law, Privacy, Civil Rights and more. Published, Saturday, May 3, 2026. 10 major topics, 70 subtopics. Comprehensive legal analysis. 1. Supreme Court landmark decisions and pending rulings. The Supreme Court of the United States enters May 2026 in its critical writing period, with a docket laden with some of the most consequential cases in a generation. On April 29, 2026, the court issued two significant opinions: Louisiana v. Calais and First Choice Women's Resource Centers v. Davenport, signaling the intensity of this term's final stretch. The justices are expected to hand down the remaining merits decisions by late June or early July, including the closely watched Trump v. Barbara case concerning birthright citizenship, which was argued on April 1, 2026. Meanwhile, the abortion pill dispute involving mifepristone access has returned to the court after lower courts issued conflicting rulings. The geofence warrant case raises pressing Fourth Amendment questions about digital surveillance in the smartphone era. Each of these cases carries the potential to reshape fundamental areas of American law for decades to come. Court watchers and legal scholars are bracing for what many are calling the most transformative term since 2021 to 2022. The court's February 2026 ruling in Learning Resources Incorporated v. Trump, which struck down the president's emergency tariffs under the International Emergency Economic Powers Act, IEPA, continues to reverberate across the legal and economic landscape. Chief Justice John Roberts authored the 6-3 majority opinion, joined by Justices Sotomayor, Kagan, Gorsuch, Barrett, and Jackson, holding that IEPA does not authorize the president to impose tariffs unilaterally. The ruling drew sharp criticism from the president, who publicly attacked the two conservative justices who voted against him. The tariff decision established a significant precedent regarding the separation of powers and congressional authority over taxation. Legal analysts note that the court's willingness to check executive overreach in the tariff context may signal how the justices will approach the birthright citizenship question. The term has already produced a remarkable number of cases where the court has pushed back against executive branch action. The April 27, 2026 grant of certiorari in Department of Labor v. Sun Valley Orchards added yet another blockbuster case to the pipeline, testing whether federal agencies can constitutionally impose monetary penalties through administrative law judges rather than Article III courts. This case follows directly from the court's 2024 ruling in SEC v. Jarkissi, which held that defendants facing civil penalties have a Seventh Amendment right to a jury trial. The Sun Valley case will be argued in the fall and decided in the 2026 to 2027 term, but its implications are already generating significant commentary. The Hensley v. Fluor Corp decision from April 22 further clarified limits on federal preemption of state tort claims. Additionally, the Enbridge Energy v. Nestle ruling established that the 30-day deadline for removing cases to federal court under 28 U.S.C. 1446, b.1, cannot be equitably tolled. Together, these decisions paint a picture of a court deeply engaged in defining the boundaries of federal power. 1. A birthright citizenship executive order challenge. The Trump v. Barbara case, argued before the Supreme Court on April 1, 2026, stands as one of the most significant constitutional cases of the modern era. At issue is Executive Order 14160, titled, Protecting the Meaning and Value of American Citizenship, which purported to end birthright citizenship for children born in the United States to undocumented immigrants or temporary residents. The order was immediately blocked by 3 separate federal district court injunctions, each finding the order likely unconstitutional under the 14th Amendment's Citizenship Clause. The administration initially challenged the scope of nationwide injunctions, but the court ultimately agreed in December 2025 to hear the case on the merits. California Attorney General Rob Bonta has estimated that the order would deny citizenship to between 20,000 and 24,000 babies born in California each year. Legal scholars broadly agree that the plain text of the citizenship clause, all persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens, presents a formidable barrier to the administration's position. A decision is expected by the end of June 2026. 1B abortion pill dispute returns to Supreme Court. The legal battle over the widely used abortion medication mifepristone has returned to the Supreme Court after conflicting rulings in the lower courts created an untenable split. Last term, the court unanimously dismissed FDA v. Alliance for Hippocratic Medicine on standing grounds, but new plaintiffs have brought fresh challenges that the courts have found justiciable. The current dispute centers on whether the FDA's 2016 and 2021 relaxations of prescribing requirements for mifepristone exceeded the agency's statutory authority. A federal judge in Texas issued a ruling restricting mifepristone access, while the Fifth Circuit partially upheld that order, creating a direct conflict with rulings from other circuits. Reproductive rights organizations have warned that a ruling against the FDA could effectively eliminate medication abortion, which accounts for more than 60% of all abortions in the United States. The pharmaceutical industry has filed amicus briefs arguing that destabilizing FDA drug approvals would create catastrophic uncertainty across the entire regulatory framework. The case is expected to be decided alongside other major end-of-term rulings in June. 1C Louisiana v. Calais Voting Rights Act ruling. On April 29, 2026, the Supreme Court issued its 6-3 ruling in Louisiana v. Calais, striking down Louisiana's congressional map that had created a second majority black district. Justice Samuel Alito authored the majority opinion, holding that because Section 2 of the Voting Rights Act did not require Louisiana to create the additional district, no compelling interest justified the state's use of race in its map-making. The decision fundamentally alters the legal framework for evaluating vote dilution claims, requiring evidence of a strong inference that the state intentionally drew districts to afford minority voters less opportunity because of their race. Justice Elena Kagan, in a dissent read from the bench a signal of profound disagreement, warned that the majority had rendered Section 2 all but a dead letter. The ruling has immediate implications for the 2026 midterm elections, as Louisiana must now redraw its congressional map. Civil rights organizations have described the decision as the most damaging blow to the Voting Rights Act since Shelby County v. Holder in 2013. The practical effect of the ruling may extend far beyond Louisiana, discouraging states from creating majority-minority districts even where demographic patterns would support them. 1D First Choice Women's Resource Centers v. Davenport, First Amendment. Also decided on April 29, 2026, the court's ruling in First Choice Women's Resource Centers Incorporated v. Davenport addressed the intersection of First Amendment associational rights and government investigatory power. The case arose from a 42 U.S.C. 1983 suit challenging a subpoena issued by the New Jersey Attorney General demanding internal documents and donor information from faith-based pregnancy centers. The Supreme Court held that First Choice had established a present injury to its First Amendment associational rights sufficient to confer Article III standing. The ruling did not decide the merits of the underlying First Amendment claim, but the standing determination itself is significant because it allows organizations to challenge government subpoenas before being forced to comply. Legal commentators have noted that the decision could have broad implications for nonprofit organizations, advocacy groups, and religious institutions facing governmental demands for donor and member information. The case now returns to the lower courts for a determination on the merits. Pro-life organizations hailed the ruling as a victory for religious freedom and associational privacy. 1. Geofence warrants and Fourth Amendment privacy. The Supreme Court is poised to address one of the most pressing digital privacy questions of the era, whether geofence warrants that compel technology companies to identify every device present within a geographic area during a specified time violate the Fourth Amendment. These warrants have been used extensively by law enforcement to identify suspects by obtaining location data from Google and other companies for all users near a crime scene. Civil liberties organizations, including the ACLU and the Electronic Frontier Foundation, have argued that geofence warrants are the digital equivalent of general warrants that the founders explicitly prohibited. The warrants sweep up data from potentially thousands of innocent people to identify a handful of suspects. Lower courts have split on the constitutionality of geofence warrants, with some finding they satisfy the Fourth Amendment's particularity requirement and others holding they do not. The court's decision could set the first major precedent on mass digital surveillance since Carpenter v. United States, 2018, which required warrants for cell site location information. Technology companies themselves have filed amicus briefs supporting limits on geofence warrants, arguing that compliance imposes extraordinary burdens and undermines user trust. 1F Sun Valley Orchards, Federal Agency Enforcement Power. The Supreme Court's April 27, 2026 grant of certiorari in Department of Labor v. Sun Valley Orchards, LLC sets the stage for a major ruling on the constitutionality of federal agency enforcement. The case involves a New Jersey farm that was assessed approximately $500,000 in penalties by the Department of Labor for alleged violations of the H-2A Temporary Agricultural Worker Visa program. Sun Valley Orchards challenged the penalties, arguing that the dole's administrative law judge system is unconstitutional under the Supreme Court's 2024 decision in SEC v. Jarkissi, which found that defendants facing civil penalties are entitled to a trial in an Article III federal court. The Third Circuit agreed with Sun Valley, holding that H-2A labor certification regulations involve domestic policy rather than the admission and exclusion of aliens, and therefore fall outside the narrow public rights exception. The dole, represented by Solicitor General D. John Sauer, argues that the enforcement mechanism is permissible because it involves immigration-related public rights. Sun Valley is represented by the Institute for Justice, which has made agency enforcement reform a signature issue. Oral argument is expected in the fall of 2026, with a decision likely in the first half of 2027. 1G Generic Drug Manufacturer Liability Case. The Supreme Court's docket also includes a case with major implications for pharmaceutical liability law, specifically whether generic drug manufacturers can be held liable under state tort law for injuries caused by inadequate warnings on their products. Under current law established by Pliva Incorporated v. Menzing, 2011, generic manufacturers are largely shielded from failure to warn claims because federal law requires their labels to match those of the brand name drug. The new case presents updated arguments about whether generic manufacturers have independent duties under state law that are not preempted by federal requirements. Plaintiffs' attorneys argue that the current framework creates an unjust system where patients injured by identical medications receive different legal protections based solely on whether their pharmacist dispensed the brand name or generic version. The pharmaceutical industry has vigorously defended the preemption doctrine, arguing that imposing liability on generic manufacturers would increase drug costs and reduce access. Consumer advocacy groups counter that the current system effectively immunizes manufacturers of the vast majority of prescription drugs, since generics account for approximately 90% of prescriptions filled in the United States. The case could reshape pharmaceutical tort litigation for millions of Americans. 2. Immigration law and enforcement policy shifts. Immigration law is undergoing dramatic transformation in the spring of 2026, as the Trump administration intensifies enforcement, implements new vetting procedures, and faces legal challenges across multiple fronts. U.S. Citizenship and Immigration Services, USCIS, announced on April 27, 2026, that it has begun applying enhanced security checks to many immigration benefit applications that require fingerprints, including green card and naturalization cases. Internal guidance instructed officers not to approve affected cases until expanded criminal history record information from FBI fingerprint-based background checks is complete. The House of Representatives advanced a budget outline that could lead to $70 billion in additional immigration enforcement funding over 3 years, passing 215 to 211 with no Democratic support. The Board of Immigration Appeals issued a consequential ruling in matter of Santiago, holding that DACA status alone is insufficient to terminate removal proceedings. These policy and legal changes represent the most aggressive restructuring of the U.S. immigration system in decades. The legal landscape for temporary protected status, TPS, holders remains deeply uncertain, as the administration has moved to terminate TPS designations for multiple countries while facing judicial pushback. Secretary of Homeland Security Kristi Noem has determined that Venezuela, South Sudan, Haiti, and Syria no longer meet conditions for TPS designation, but federal courts have repeatedly stayed these termination decisions. A judge in the U.S. District of Massachusetts stayed multiple TPS termination decisions, even after DHS prevailed twice at the Supreme Court in similar cases. The administration has also expanded its travel ban to include 15 additional countries, drawing comparisons to the original travel ban litigation that reached the Supreme Court in Trump v. Hawaii, 2018. The May 2026 Visa Bulletin became active on May 1, listing updated final action dates and dates for filing for both family-based and employment-based categories. Applicants adjusting status must additionally check which chart USCIS allows for filing. The convergence of enforcement actions, court battles, and administrative changes has created a climate of deep anxiety among immigrant communities. On April 28, 2026, the Department of Homeland Security announced an interim final rule implementing immigration fees and requirements from the H.R. 1 Reconciliation Act of 2025, also known as the One Big Beautiful Bill Act. The rule introduces consequences for unpaid annual asylum fees, which could result in the denial of pending asylum applications for non-payment. Immigration attorneys have expressed alarm that the fee requirements will disproportionately burden asylum seekers fleeing persecution who often arrive in the United States without financial resources. USCIS fraud detection efforts continue to produce results, with 2 guilty pleas in an H-1B fraud conspiracy case announced on April 23, 2026. The H-2B visa program reached its cap for the second allocation of returning workers for fiscal year 2026, with 27,736 additional visas used for workers with start dates from April 1 to April 30. Immigration advocates urge affected individuals to consult qualified legal professionals and keep identity documents, USCIS receipts, and emergency contact plans readily accessible. The pace and scope of changes make it essential for immigrants and employers alike to monitor developments closely and seek legal counsel. 2. USCIS enhanced security checks for applicants. Beginning April 27, 2026, USCIS implemented enhanced security checks for a wide range of immigration benefit applications that require biometric submissions, including Green Card, Form I-485, and Naturalization, Form N-400, cases. Internal agency guidance directs officers to hold cases pending until expanded criminal history record information is returned from FBI fingerprint-based background checks. The enhanced checks draw on broader databases and more comprehensive cross-referencing than the previous system, which immigration attorneys say could add weeks or months to processing times. USCIS has not publicly specified which additional databases are being queried or the expected timeline for the enhanced checks to be completed. Immigration lawyers report that the new procedures are already causing delays in case adjudications across service centers and field offices nationwide. Advocacy organizations have raised concerns about potential due process implications, particularly for applicants who may face immigration consequences if their status lapses during the extended processing period. The administration has defended the enhanced checks as necessary to protect national security and ensure that immigration benefits are not granted to individuals who pose risks. 2B House advances $70 billion immigration enforcement plan. The U.S. House of Representatives approved a budget outline in late April 2026 that establishes the framework for up to $70 billion in new immigration enforcement funding over 3 years. The measure passed on a party line vote of 215 to 211, with no Democratic support, following Senate action on April 23. The funding plan encompasses expanded ICE detention capacity, additional Border Patrol agents, construction and maintenance of border barriers, and technology upgrades for surveillance and processing. Critics argue that the massive enforcement investment comes at the expense of legal immigration pathways, refugee resettlement programs, and immigration court resources that are already strained by a backlog exceeding 3 million cases. Supporters contend that robust enforcement is a prerequisite for any broader immigration reform and that border security is a fundamental sovereign function. The budget outline must still be translated into specific appropriations bills, which will face further debate and potential amendment. Immigration policy experts note that enforcement-only approaches have historically failed to address the root causes of unauthorized migration, including economic conditions and violence in sending countries. 2 CDACA recipients face new legal risks in removal proceedings. The Board of Immigration Appeals, BIA, issued a precedential decision in matter of Santiago that significantly changes the legal landscape for DACA, deferred action for childhood arrivals, recipients who are in removal proceedings. The BIA held that DACA status alone is not sufficient grounds for an immigration judge to terminate or administratively close removal proceedings. Under the ruling, immigration judges must now consider DHS opposition and other relevant factors before ending a case, meaning that DACA recipients can no longer assume their deferred action status provides protection from active removal proceedings. The decision is particularly alarming because it arrives at a time when the DACA program itself faces ongoing constitutional challenges and the administration has signaled its intent to wind down the program. Immigration attorneys are advising all DACA recipients with pending or prior removal proceedings to seek legal counsel immediately and review their options. The ruling could affect hundreds of thousands of individuals who have relied on DACA for work authorization and protection from deportation since the program's creation in 2012. Legal experts warn that the intersection of the BIA ruling with other enforcement initiatives could leave DACA recipients in an increasingly precarious position. 2 DTPS cases for Haitian and Syrian nationals at Supreme Court. The legal battle over temporary protected status designations for nationals of Haiti and Syria has escalated to the Supreme Court level, as the administration seeks to reverse lower court orders that have stayed TPS terminations. Secretary Kristi Noem has determined that these countries no longer meet the statutory conditions for TPS designation, citing changed country conditions. However, federal judges in the District of Massachusetts have issued stays preventing the terminations from taking effect, finding that TPS holders are likely to succeed on the merits of their claims. The DHS has expressed vehement disagreement with these judicial orders, particularly given that the Supreme Court ruled in the administration's favor in similar TPS cases involving Venezuela in October 2025. TPS holders from Haiti and Syria currently maintain work authorization and protection from deportation under the court orders, but their status remains precarious. Legal advocates are urging affected individuals to explore backup immigration options with qualified attorneys. The resolution of these cases will determine the fate of tens of thousands of individuals who have built lives and families in the United States over many years of TPS protection. 2E expanded travel ban adds 15 countries. The Trump administration has expanded its travel restrictions to include 15 additional countries, bringing the total number of nations subject to enhanced vetting or outright entry bans to a level not seen since the original travel ban executive orders. The expanded ban imposes varying levels of restrictions depending on the country, ranging from complete visa suspension to enhanced screening requirements for certain visa categories. The administration justifies the expansion on national security grounds, citing inadequate information sharing by the affected countries and concerns about terrorism and immigration fraud. Civil rights organizations have immediately challenged the expanded ban in federal court, arguing that it constitutes religious and national origin discrimination in violation of the Immigration and Nationality Act and the Establishment Clause of the First Amendment. The legal challenges will likely cite the Supreme Court's 2018 ruling in Trump v. Hawaii, which upheld the original travel ban but left open the possibility that future restrictions could be challenged on different factual grounds. Business and academic organizations have expressed concern about the impact on international students, visiting scholars, and professional workers. Affected individuals are advised to check the latest country-specific guidance and consult immigration counsel before making travel plans. 2F May 2026 Visa Bulletin Updates and Wait Times. The May 2026 Visa Bulletin became active on May 1, 2026, and contains updates to both the final action dates and dates for filing charts for family-based and employment-based immigrant visa categories. For applicants pursuing adjustment of status within the United States, it is essential to check which chart USCIS designates as the controlling chart for filing purposes each month. The employment-based categories continue to show significant backlogs for applicants born in India and China, with some EB2 and EB3 priority dates remaining several years behind current dates. Family-based categories similarly reflect extended wait times, with the F2B category for unmarried adult children of permanent residents showing waits exceeding a decade for some countries. Immigration attorneys advise applicants whose priority dates are approaching eligibility to begin assembling documentation well in advance so they can act promptly when their date becomes current. The Visa Bulletin is published monthly by the Department of State and is one of the most important tools for individuals navigating the legal immigration system. Tools such as Green Card Wait Time Estimators can help applicants understand their individual situations and plan accordingly. 2G New Asylum Fee Rule threatens application denials. The Department of Homeland Security announced on April 28, 2026, an interim final rule implementing new asylum fee requirements under the H.R. 1 Reconciliation Act of 2025. The rule establishes consequences for the non-payment of annual asylum fees, including the potential denial of pending asylum applications. This represents a significant departure from the historical treatment of asylum as a humanitarian protection for which fees were not charged, reflecting the principle that individuals fleeing persecution should not be barred from protection by inability to pay. Immigration advocacy organizations have condemned the fee rule as creating an unconstitutional barrier to asylum, arguing that it violates the Refugee Act of 1980 and international obligations under the 1951 Refugee Convention. The rule includes limited fee waiver provisions, but attorneys report that the waiver criteria are narrowly defined and the application process is burdensome. Legal challenges to the fee rule are expected imminently, with multiple organizations preparing complaints for filing in federal court. Asylum seekers are advised to consult with qualified legal representatives to understand their obligations under the new rule and to explore fee waiver eligibility before deadlines pass. 3. Trade law and the Supreme Court tariff showdown. The Supreme Court's February 20, 2026 decision in Learning Resources Incorporated v. Trump and Trump v. VOS Selections Incorporated constituted one of the most significant rulings on the separation of powers and trade authority in modern American history. By a vote of 6-3, the court held that the International Emergency Economic Powers Act, IEPA, does not authorize the president to impose tariffs unilaterally. Chief Justice John Roberts wrote the majority opinion, reasoning that the word regulate in IEPA does not encompass the power to impose tariffs, which are different in kind, not degree, from IEPA's other authorities. The ruling invalidated tariff programs on imports from Canada, Mexico, and China, as well as reciprocal tariffs on most other imports, which had collectively generated approximately $175 billion in revenue. The administration responded swiftly by invoking alternative statutory authority under Section 122 of the Trade Act of 1974. The decision has reshaped the entire trade policy landscape and forced the administration to pursue tariff authority through more constitutionally constrained channels. Within days of the Supreme Court ruling, President Trump signed an executive order imposing a 10% tariff on most global imports under Section 122 of the Trade Act of 1974, which took effect on February 24, 2026. Section 122 grants the president limited authority to impose temporary import surcharges of up to 15% for a maximum of 150 days, with certain exceptions, when the United States faces large and serious balance of payments deficits. Goods qualifying for USMCA, U.S. Mexico-Canada Agreement, treatment are exempt from the new Section 122 tariffs, though de minimis duty-free treatment remains suspended. The administration has simultaneously signaled its intent to pursue expedited Section 301 investigations to maintain the global tariff framework and potentially impose additional country-specific tariffs beyond the 150-day Section 122 window. Importers who paid IEPA tariffs face complex questions regarding potential refunds, as the Supreme Court's decision did not directly address the availability of relief for tariffs already collected. Trade lawyers are advising clients to evaluate strategies to preserve refund claims promptly. The legal and commercial uncertainty has created significant disruption across global supply chains. The tariffs imposed under Section 232 of the Trade Expansion Act of 1962 on steel and aluminum imports, as well as the Section 301 tariffs on Chinese goods, remain in effect and were not affected by the Supreme Court's IEPA ruling. The Section 232 tariffs were originally upheld by the courts based on the 1976 Supreme Court precedent in Federal Energy Administration v. Algonquin SNG Incorporated, which found that the term, adjust imports, in Section 232 authorized the President to impose tariffs. The IEPA ruling explicitly distinguished this precedent, noting that Section 232's grant of authority is more specific than IEPA's general language. Section 301 tariffs on approximately $370 billion in Chinese imports remain subject to ongoing trade negotiations and periodic review. businesses face a patchwork of tariff authorities, each with different legal bases, durations, and potential challenges. The overall tariff burden on American importers and consumers remains historically elevated despite the IEEPA ruling. Trade associations have called on Congress to exercise its constitutional authority over tariffs more directly and to provide greater predictability for American businesses. 3. A Supreme Court declares emergency tariffs unconstitutional. The 6-3 ruling in Learning Resources Incorporated v. Trump established a landmark precedent that emergency economic powers do not encompass the authority to impose tariffs, a power the Constitution specifically assigns to Congress under Article I, Section 8. Chief Justice Roberts, writing for a majority that included both liberal and conservative justices, applied the major questions doctrine requiring clear congressional authorization for actions of great economic and political significance to conclude that IEEPA lacks the requisite clarity. The court observed that interpreting IEEPA to authorize tariffs would also raise constitutional problems under the Export Clause, since IEEPA allows the President to regulate both importation and exportation, and the Constitution prohibits export taxes. Justices Thomas, Kavanaugh, and Alito dissented, arguing that the broad language of IEEPA should be read to encompass tariff authority. The decision immediately invalidated tariffs that had been in effect for over a year, creating complex questions about refunds, contractual obligations, and supply chain adjustments. Trade lawyers described the ruling as the most consequential trade law decision in half a century. The case is expected to generate years of follow-on litigation regarding refund claims and the validity of tariffs collected before the ruling. 3B President pivots to Section 122 Trade Act authority. Following the Supreme Court's invalidation of IEEPA tariffs, the President invoked Section 122 of the Trade Act of 1974 as alternative statutory authority for imposing a 10% global tariff effective February 24, 2026. Section 122 authorizes the President to impose temporary import surcharges when the United States faces large and serious balance of payments deficits that threaten the international monetary system. The authority is limited to tariffs of no more than 15% in a duration of 150 days, after which congressional approval would be required for extension. The administration argues that the current trade deficit exceeding $1 trillion annually satisfies the statutory threshold. Legal scholars have questioned whether Section 122 was intended to address structural trade imbalances or only acute currency crises, and litigation challenging the new tariffs has already been filed. The USMCA exemption means that qualifying goods from Canada and Mexico are not subject to the Section 122 tariffs, but many goods do not qualify for USMCA preferential treatment. The 150-day clock means the Section 122 tariffs will expire in late July 2026 unless the administration finds additional legal authority or Congress acts. 3C Steel, aluminum, and China tariffs remain in force. While the IEEPA tariffs were struck down, the Section 232 tariffs on steel, 25%, and aluminum, 10%, imports, and the Section 301 tariffs on Chinese goods, remain fully in effect and were not challenged in the Supreme Court litigation. Section 232 tariffs are based on the President's authority to restrict imports that threaten national security, an authority upheld by the Court of International Trade and the Federal Circuit. The China tariffs under Section 301, originally imposed to address intellectual property theft and forced technology transfer, cover approximately $370 billion in Chinese imports at rates ranging from 7.5% to 25%, with some categories facing even higher rates. American manufacturers that depend on imported steel and aluminum continue to bear elevated input costs, which are often passed through to consumers. Trade economists estimate that the cumulative tariff burden across all authorities has increased the average cost of imported goods by approximately 5 to 8%. Efforts to negotiate bilateral trade agreements that could reduce tariff rates have stalled amid broader geopolitical tensions. American businesses continue to call for a rationalized tariff framework that provides certainty and reduces compliance complexity. 3D Business community reacts to tariff uncertainty. The business community's reaction to the shifting tariff landscape has been marked by frustration, uncertainty, and calls for congressional action. The U.S. Chamber of Commerce, the National Retail Federation, and numerous trade associations have issued statements urging Congress to reassert its constitutional authority over tariffs and provide a stable, predictable trade environment. Small and mid-sized importers have been particularly affected, as they lack the resources of large corporations to absorb tariff costs, renegotiate supplier contracts, or rapidly diversify supply chains. Major retailers have warned that continued tariff instability will inevitably lead to higher consumer prices, particularly for electronics, clothing, and household goods. Financial markets have experienced volatility tied to tariff announcements, with the S&P 500 showing significant sensitivity to trade policy developments. Supply chain managers report that the rapid switching between tariff regimes from IEEPA to Section 122 has made long-term planning nearly impossible. The uncertainty premium is estimated to have reduced business investment by measurable percentages during the first quarter of 2026, according to multiple economic analyses. 3. International trade partners respond to ruling. International trade partners have responded to the Supreme Court's tariff ruling with a mixture of relief and caution, recognizing that while the IEEPA tariffs were struck down, substantial tariffs remain in place under other statutory authorities. The European Union has signaled willingness to resume trade negotiations but has maintained its retaliatory tariffs pending concrete steps by the United States. Canada and Mexico have emphasized the importance of the USMCA framework and urged the United States to honor its commitments under the agreement. China has maintained its own retaliatory tariffs and has shown little indication of making concessions while the Section 301 tariffs remain in effect. The World Trade Organization has multiple pending complaints against the United States related to various tariff programs, though the organization's dispute resolution mechanism has been weakened by U.S. opposition to appointing new appellate body members. Developing countries that were swept into the IEEPA tariff regime have expressed particular relief at the ruling, as their economies are disproportionately affected by broad-based tariffs. The international legal consensus is that the Supreme Court ruling reaffirms the principle that trade policy should be conducted through constitutionally authorized channels rather than emergency powers. 3. Constitutional separation of powers in taxation. The Learning Resources ruling has reinvigorated scholarly and political debate about the constitutional separation of powers as it relates to taxation and trade. The Constitution vests the taxing power exclusively in Congress under Article I, Section 8, and the founders viewed this power as one of the most important checks on executive authority. Over the past century, Congress has delegated increasing trade authority to the President through statutes like the Trade Act of 1974, Section 232, and IEEPA, raising questions about whether such delegations have become excessively broad. The Supreme Court's application of the major questions doctrine to trade authority suggests a willingness to scrutinize broad statutory delegations in this context. Legal scholars have noted parallels to the non-delegation doctrine, which holds that Congress cannot delegate its legislative authority without providing an intelligible principle to guide executive action. The ruling may encourage Congress to reclaim its trade authority more directly, either through new legislation or by narrowing existing delegations. The political dynamics of trade policy, however, make significant congressional action difficult, as members of both parties benefit from delegating politically difficult tariff decisions to the executive branch. 3. Legal challenges to Section 122 tariffs already brewing. Within weeks of the President's invocation of Section 122 authority, multiple legal challenges have been filed in the U.S. Court of International Trade by importers and trade associations. Plaintiffs argue that the current trade deficit, while large, does not constitute the type of acute balance of payments crisis that Section 122 was designed to address. Legislative history suggests that Section 122 was enacted in response to the 1971 Nixon shock, the suspension of dollar convertibility to gold, and was intended for temporary currency and balance of payments emergencies rather than structural trade imbalances. Legal challengers also argue that the President's invocation of Section 122 is pretextual, noting that the administration's stated goals relate to industrial policy and geopolitical leverage rather than balance of payments concerns. The government has responded by arguing that the statutory text grants broad discretion to the President and that the courts should defer to the executive's determination of what constitutes a qualifying deficit. Given the 150-day time limit on Section 122 tariffs, some observers question whether the courts will act quickly enough to decide the merits before the tariffs expire on their own terms. The litigation trajectory could ultimately lead these questions back to the Supreme Court in a future term. 4. Employment discrimination and workplace rights. The field of employment discrimination law is experiencing a period of unprecedented activity, with federal discrimination lawsuits surpassing 20,000 annual filings in fiscal year 2025 and showing no signs of slowing in 2026. The Equal Employment Opportunity Commission, EEOC, under the leadership of Chair Andrea Lucas, has adopted a markedly different enforcement posture, shifting significant resources toward investigating what the agency characterizes as reverse discrimination, cases where members of majority groups allege discrimination on the basis of race, sex, or other protected characteristics. Disability accommodation claims have surged by 42%, driven in part by post-pandemic workplace restructuring and the expansion of remote work policies. The EEOC's $15 million conciliation agreement resolving COVID-19 vaccination discrimination charges against a global technology company represents the largest settlement of its kind. California continues to set national benchmarks for worker protections through expansive state legislation. The convergence of shifting enforcement priorities, rising case volumes, and evolving workplace norms is creating a highly dynamic legal environment for employers and employees alike. The EEOC's emphasis on reverse discrimination cases represents a significant philosophical shift in the agency's enforcement approach. Chair Lucas has publicly called on Fortune 500 executives to ensure compliance with Title VII, specifically warning that diversity, equity, and inclusion (DEI) programs that make employment decisions based on race, sex, or other protected characteristics are unlawful. The agency has issued guidance documents helping employees identify and report DEI-related discrimination, which it defines as any employment action motivated in whole or in part by a protected characteristic. This enforcement posture has been bolstered by the Supreme Court's unanimous ruling in Ames, which Chair Lucas celebrated as restoring even-handed application of Title VII. Civil rights organizations have criticized the EEOC's shift, arguing that it conflates lawful diversity initiatives with illegal quota systems and chills voluntary employer efforts to address documented disparities. Employment attorneys report that the changing enforcement climate has prompted many employers to restructure or rebrand their diversity programs to reduce legal exposure. The tension between the agency's current priorities and long-standing civil rights enforcement norms is expected to generate significant litigation throughout 2026 and beyond. Working mothers continue to face persistent workplace discrimination that manifests in hiring decisions, promotion denials, reduced responsibilities, and outright termination following pregnancy or maternity leave. Studies show that mothers face a measurable motherhood penalty in wages, earning approximately 4 to 7% less per child compared to childless women, while fathers experience no comparable penalty and in some studies receive a fatherhood bonus. The growth of pro-se employment plaintiffs, individuals who file discrimination lawsuits without attorney representation, continues to strain federal courts, with studies showing that pro-se plaintiffs prevail in fewer than 5% of cases. The barriers facing pro-se plaintiffs include difficulty navigating complex procedural requirements, inability to conduct effective discovery, and challenges in presenting expert testimony. Employment attorneys note that the contingency fee model has become less available for smaller discrimination claims, leaving many workers without viable representation options. Legislative proposals to simplify employment discrimination procedures and provide greater access to legal assistance have gained support but face uncertain prospects in the current Congress. The overall picture is one of rising demand for workplace justice amid structural barriers that limit access to effective legal remedies. Federal discrimination lawsuits surpassed 20,000 annual filings. Federal courts received more than 20,000 employment discrimination lawsuit filings in fiscal year 2025, representing the highest total in over a decade and a continuation of a multi-year upward trend. The increase is attributed to several factors, including heightened public awareness of workplace rights, the expansion of protected categories under state and federal law, and the post-pandemic restructuring of work arrangements that has generated new categories of disputes. Title VII claims related to race, sex, and religion continue to account for the largest share of filings, but claims under the Americans with Disabilities Act, ADA, and the Age Discrimination in Employment Act, ADEA, have grown substantially. The EEOC received approximately 81,000 new discrimination charges in FY 2025, the highest level since 2010, reflecting increased willingness among workers to assert their rights. Courts have struggled to manage the growing caseload, with median time to disposition in employment discrimination cases exceeding 12 months in many jurisdictions. The trend shows no signs of abating, with early FY 2026 data suggesting continued growth in filing rates. Legal scholars attribute the surge in part to broader societal debates about equity, identity, and workplace culture that have heightened sensitivity to discriminatory conduct. 4B Disability accommodation claims surge 42%. Claims related to disability accommodation in the workplace have increased by 42% year-over-year, reflecting the profound impact of the pandemic on how employers and employees understand workplace accessibility and flexibility. The ADA's requirement that employers provide reasonable accommodations unless doing so would cause undue hardship has been tested repeatedly by disputes over remote work, modified schedules, and medical leave policies. Employers who expanded remote work during the pandemic and then mandated return-to-office policies have faced a wave of accommodation requests from employees with disabilities who argue that remote work was demonstrated to be feasible and effective. Courts have generally held that the fact that remote work was possible during a temporary emergency does not automatically establish it as a reasonable accommodation under normal circumstances, but the analysis is highly fact-specific. The EEOC has issued updated guidance clarifying that long COVID can qualify as a disability under the ADA when it substantially limits one or more major life activities. Mental health accommodations, including requests for reduced workloads, flexible scheduling, and workplace modifications to reduce anxiety triggers, have become an increasingly significant category of claims. The surge in disability claims underscores the need for employers to develop robust, well-documented interactive processes for evaluating accommodation requests. 4C EEOC shifts focus to reverse discrimination cases. Under Chair Andrea Lucas, the EEOC has made reverse discrimination enforcement a centerpiece of its strategic priorities, investigating and pursuing cases where employers allegedly discriminated against members of majority racial or gender groups in connection with DEI programs. The agency has issued a "What You Should Know" document on DEI-related discrimination at work, defining it broadly as any employment action motivated by race, sex, or another protected characteristic, regardless of the group to which the affected individual belongs. The EEOC has also published resources on national origin discrimination, emphasizing that protections apply to all workers regardless of their country of origin. Chair Lucas has called on companies to review their DEI initiatives for potential Title VII violations and to ensure that programs are designed to increase opportunities